Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
All right, well, good afternoon, everyone, and welcome back to what I like to call the CNC Subrogation Factory. My name is Chris Aguiar. I'm a vice president here in our recovery division at the FIA Group. With me today, I have Cindy Merrell. Cindy, you want to introduce yourself again?
Hi, friends. I'm Cindy Merrell. I'm an attorney in the Louisville office, and I work with Chris in subrogation.
I still really badly want to see if we can get some CNC Music Factory music into this thing. But I don't know if we have to take
less than 30 seconds for that copyright, but I think we can probably do it.
No, it's not right. I don't know anything about copyright law, but I certainly was concerned that we'd have to start paying them royalties to a 90s band that who knows if they even tour anymore. I'm not even sure I can call them a band per se. In any event, that's a whole discussion for a whole other podcast that's not in this series. So again, thanks so much, everyone, for joining us. Cindy and I, again, we must be doing well in the ratings because they keep putting us back together. So obviously, Cindy and I focus our entire time in the subrogation and third-party recovery arena. And today we want to talk about a murky area of subrogation and third-party recovery. You know, I often tell clients, sometimes there are terms in the plan documents, specifically in the subro and recovery right provisions, that are nice to have, but you don't necessarily want to have to enforce them. And that's because the issues are so murky that you want the leverage that it could create to say to a lawyer, hey, do you really want me to get more heavily involved and muck this up a bit? And hopefully that threat, certainly coming from within the ERISA context, makes plaintiffs' lawyers, who are primarily state law experts, if you will, tremble at the thought that we might come in here with the big bad ERISA hammer and really make their lives difficult. And, you know, wrongful death is one of those areas that anyone that's telling you it's, your language says it accordingly, is simply oversimplifying the reality. Cindy, you want to kind of kick us off a little bit? I know you had a case that was a good one that you like to utilize in this arena.
Sure. So I think the first thing that we should talk about is what's the difference between wrongful death and a survival action? And unfortunately, it's not a clear answer. Anything that we start talking about murky, it makes us a little, there's a lot of heave and hine, and basically a wrongful death claim and a survival action, depending on the jurisdiction. Typically, a wrongful death claim, it allows compensation for the survivors. It's for the benefit of the survivors, for the member of the deceased. So think about it. They're claiming the lost wages that they would have been able to receive if the member were to have survived. And then the survival action is if the member had not been deceased, their claim. So think of it typically wrongful death to the benefit of the heirs, and survival would have been, but for the member's death, the member would have been able to make those claims. And there is, in each jurisdiction, some courts and some states will allow it to be one and the same. They'll say that there is no distinction. They have to bring essentially all claims against the third party. Or there are some jurisdictions in which they make it clearly defined the medical expenses can't even be brought in a wrongful death claim. They can't even be compensated for. So one of the cases I want to talk about is a murky one. It's in Pennsylvania. And the case is called Aguiar versus American National Property and Casualty. But essentially, the member was a member on a self-funded ERISA plan. And this court case is out of the Western District of Pennsylvania. And the member died as a result of a motor vehicle wreck. And the heirs brought forth a claim against the third party. The heirs in Pennsylvania, they're one of those states where there's not really, medicals could be claimed under either wrongful death or survival. So we would typically say, well, then we're entitled to medical expenses. And that's exactly what the health plan involved in this case did, is they brought an action and trying to seek reimbursement pursuant to their plan document. And so essentially the court said, you know what, plan? The family never agreed to your plan document. They are not a beneficiary of that, and they are entitled to all of the settlement funds. Now let's put that against some other states where if there is wrongful death, there's a possibility that the plan can seek recovery, but it's very expensive to do that. Essentially, the plan would have to retain local counsel and show up at the probate court to try to argue to get recovery back to the plan. We will, make those arguments here, but it can go as far as the plan having to retain local counsel. And even then, it's highly unlikely the court will see in favor of the plan.
I want to add some color here, and then I actually want to ask you a couple questions. And I'm sorry to put you on the spot. Maybe you don't remember the exact details, and candidly, I don't remember the case at all. So I'm in no position to to be judgy, right? So the thing about wrongful death, folks, is that it gets really murky. There's an interesting corollary I like to make, or parallel I like to make, to when minors get involved. And here's the kick, right? Reasonable people that don't understand the legalities of what's going on here will have a very hard time with the idea that the big bad insurance company, air quotes, is coming in and taking the money of the family of this dead person. To the normal human being that doesn't operate in this world, that kind of thing just does not compute. It's not fair. It's not just. Now, we know that under ERISA and all the jurisprudence we have here, in a lot of ways, these benefit plans get to determine what is fair and what is just, as long as they put it in the terms of the plan. But you still have to convince people. And people are very difficult to convince when they have their own convictions. And if you exist in today's political climate and don't understand that that's the reality of the world, then I don't know where in the world you're existing. People have their own convictions and opinions, and it's very difficult to convince them, no matter what you put in front of them, that those convictions and ideas are not necessarily applicable. And so really what you're looking at is you're a benefit plan, or as I like to say, optically, it looks like you're the big bad insurance company coming in and you're saying to a court, to a family, look, too bad, so sad. We're really sorry your family member has passed away. We're really sorry about the circumstances that led to that. But, that money is ours. Is that all technically, could we argue, technically correct? Sure. If we apply general ERISA principles here, money is being held in a constructive trust, yada, yada, yada. All of that seems perfectly normal. But on the ground, when it's going down, it just doesn't feel that way. So you're going to have to convince a judge. Now, here's a question on this one. Cindy, was this litigated in the state courts or in the federal courts?
It was litigated in the state courts, but that was because there's a whole bunch of procedures involved in this one. There's a bankruptcy and there was some other issues that are outside of the purview of this podcast. But essentially, That's why it was done. But they were citing the federal court's decisions, and that's how they ultimately got there. And I would say specifically in Pennsylvania, it is not a favorable place for.
You picked up exactly what I was putting down. You beat me to the punch. That's exactly the point I wanted to make. You're in a Pennsylvania court. Pennsylvania is not a full-blown anti-subrogation, but they're pretty close. And regardless of how close they are or are not, I can tell you right now, most of the practitioners in the state of Pennsylvania don't like Cindy and I very much. And when I say
We're not
Cindy
on their Christmas card list. Let's just say that.
When I say Cindy and I mean as the beacons or representatives of the self-funded benefit plan in these worlds. And so you're sitting in a state court with a state judge who doesn't necessarily understand or care what ERISA says. And, we've seen this in the last several months at a very, very large scale, this idea that sometimes judges will make policy from the bench. Not to sort of make a reference to a rather large decision that just came out of the Supreme Court of the United States about a month ago. The point is, sometimes judges have agendas, and they will push those agendas regardless of what the law might be in front of them. So here you have a case where, and this is the second question, do you know if the terms of the plan in that case, Cindy, did it allow for allocation or characterization or any of those fun arguments where they were like, oh, no, sorry, you can't have the money because this is for something else? Did it have any of that kind of language in it?
I don't off the top of my head recall.
That's okay. I was simply going to make the point. If the plan had really strong language in that regard, hey, you're not allowed to allocate funds around us. You're not allowed to characterize funds or categorize them as something outside of how we classified these funds here for pain and suffering versus medicals, or whatever the case would be. Now, that's a little bit of me talking about strategies plans could utilize to maybe be successful. That didn't really matter in this case, at least not on its face, because what did the court say? The court basically said, there's no contractual hook here, right? How does that work? What's the mechanism you need to think about? The person that received benefits in this case was the deceased member, the deceased participant, right? So first of all, let's operate from the world that we all like to say, and it was plastered all over all these plan documents. This is not a contract, right? Certainly in our world, we don't want to be in contract land because contract land puts us in state law governance, and state law governance, especially in the state of Pennsylvania, means we get thrown out of court. So now understand that the contract, if you will, the lack of contract, if you will, here is really on a claim by claim. It is the acceptance of the benefits that creates a sort of contractual relationship on a case by case basis. But the participant's family did not accept any benefits. They did not have medical bills or damages, direct hard damages as a result of this injury. They had indirect damages, had nothing to do with their injuries in the accident, right? And so the very easy way out of these kinds of situations is for a court to do exactly what this one did, which said, hey, hold on a second, plan. How are you going to step in here? This family is bringing a claim for damages that have nothing to do with you. And the guy that agreed to accept your benefits and thereby accepted the burdens that comes with those benefits isn't even here. He's not the one holding the bag. Who are you to come in here and say that this family has some obligation to you? They don't. Have a nice day. That's the crux of what this court did. They were able to constrict the issue so much so that it was very simply, these people didn't get anything from you. Accordingly, they don't owe you anything. Sorry, too bad, so sad. Now, would it have been different in the federal court in the Third Circuit? I don't know. You know why I don't know, ladies and gentlemen? Because even the Third Circuit doesn't like it very much. I will remind you that one of the most famous subrogation cases, U.S. Airways versus McCutcheon, didn't go our way because the plan didn't have good language. But I would also remind you that at that time in the Third Circuit, the law was silence in the plan document. It will be interpreted in favor of the benefit plan. So that means you didn't need good language when the U.S. Airways case was decided for a plan to win. What did the court in U.S. Airways versus McCutcheon do? They made policy from the bench. They decided to change the rules on the fly. They didn't look at the law in front of them and say, well, the law is accordingly. They decided, nope, we're going to change the law. And so I don't think I intended or we intended to get into this whole concept of judges that decide to be legislators in these cases. But the point is, you can see how we're adding all this murk to what is a very murky situation. And to Cindy's point, I don't care how good your rights are. The more complicated the execution of those rights are, the more expensive it can be to fight over. Because we lawyers, we don't need very much. Give us an inch and we'll take a mile to argue. You give us any in and we will drag you into a lawsuit and make you spend a lot of money. Now, obviously, Cindy and I are here to help try to avoid all that. But the fact of the matter is there's a lot of levels to this, and there's a lot of unfortunate realities that, and again, a lot of times plans kind of get the sense that, well, ERISA says I can have all my money. Yeah, in theory, ERISA does say that, assuming you have all the right language, but that comes at a price. And so sometimes plans have to do a bit of a cost benefit analysis. We don't even have to get into the optics of this thing. Do you really want to be the employer that is knocking on the door of the dead guy's family? I'm sorry to be so, potentially crass, but I'm being crass and direct on purpose. I'm trying to make a point that out in the outside world, to the onlookers of all this, like other employees at that organization, how does that bend? How does that color their perception of you as their employer, or their perception of you as a commercial entity with consumers, right? All of that stuff matters. And there's been so many examples of that in this world. So I kind of went off on a tangent there. Cindy, did you have anything else you kind of wanted to bring in?
I think you added a lot of good color to it, and it's complicated and it's difficult, and those are never good conversations to have. Practice pointer, we will always ask for, if a lawsuit has been filed, we will try to verify what claims they have made. Ultimately, there's that. We have a few different strategies that we can use. We attempt to get the best, greatest recovery back to the plan. So it's not all bad news all the time, but it is definitely something that comes up, and those are typically not small medical expenses. Typically, if we have a fatality, those are big files, and the plan is looking to have an understanding of why we're telling them that it's very unlikely that there's going to be a significant recovery. It doesn't mean it's all doom and gloom, though.
Yeah, when I get on here and I say all these things, I always, in the back of my mind, I'm thinking to myself, man, these clients must think I'm against them. That's not the case at all. In fact, I tell clients all the time on these calls, folks, it is not my job to have judgments about your perspective. It is my job to educate you on the consequences of the perspectives you may have. And then it's my job to be a mirror image of you. I don't think I like the mirror image thing, because in the mirror image, aren't you technically opposites? But you get my point. It is my job to embody your philosophy as your agent, representative, working on your behalf, however you want to label our relationship. And so, but no question, sometimes when I'm having the conversation with the clients, and Cindy, I know you've experienced this, I'm saying all the things that they need to think about. And sometimes they think, oh, Chris, whose side are you on? I'm like, guys, I don't have an opinion about what you should do. I have an opinion, or I have a lot of data about the consequences of what may happen if you do X, Y, Z. You want my advice on what a lot of my clients do? Sure, I can tell you what many clients do. But you are not bound by what other people do. You are bound by the confines of your philosophies, your language, and your fiduciary duties, whatever they may be. So it's important to understand, we get on here and we try to educate you in the same way we would if we were in a live situation with a client. And these are all the same things that I might say to a client, like, hey, I'm not saying you can't, but how do you feel about what your employees might feel if they see you doing this? Those are hard conversations to have, but that's why I get paid the mediocre bucks, right? To have hard conversations. They're certainly never fun. That much I can tell you. You know, we get to come on here and I joke and I glad hands and I try to make light of these very sensitive issues, but make no mistake, there's nothing light about them. There is a process and there is an education that is required, that is necessary, so that you as the client can make all the necessary decisions to ensure the outcome, it reflects who you are as an entity and how you want to be perceived by the public and your employees, you know, whether or not the public are concerned to you. Some organizations it is, some organizations it's not. It just depends what kind of business you're in and what the unintended consequences of some of these decisions might be. But we could do a whole presentation on that alone.
It's definitely a difficult conversation to have, though, in real time. It's much better for plans if they are starting to think about these things before this happens.
100%, because what ultimately happens is, you know, plans don't necessarily see this stuff that often. And so now all of a sudden they're faced with, what are we supposed to do here? What have we done in the past? Does that have any impact on what we can do now? And the answer is sometimes yes. So it's important to make sure you're in the room with the right people that can talk you through these issues and, you know, ultimately make the best decision for you. You know, but certainly Cindy and I and the rest of the team are here to help. Luckily for you, we don't do anything but play in these sandboxes all day, every day. So we're pretty adept at, you know, giving you the tools you need to make the right decisions for you. That's really all I got. Cindy, do you think we got the message we were hoping to get today?
I think we covered it. Thank you.
Perfect. Well, thank you as always, Cindy. It's a pleasure to be able to get on here with you. It seems like once a month now. Maybe one day they'll actually ship me out to Kentucky. We'll be able to do one live in studio or something like that. I'll have to dress nicer than I am dressed at the moment. But, you know, other than that, I think it could be a lot of fun. In any event, again, thank you so much for your time, everyone, and for tuning in. Always know that we are here for you if you have any questions, concerns. If you know that there's a case that might be brewing like this, and you know, somewhere in your office or one of your clients' offices where they know that it's an accident like this happened, and now you're listening going, holy moly, do they have any idea what's coming down their pike? Pick up the phone, call us. As you can tell, I'm always happy to talk. So that's all we got. Thanks again so much, everyone, for your time. I hope you got something out of this. And we look forward to the next segment of this podcast series, whenever it might be.
Thank you all. Have a good day.
Have a great day.